dive. Today we are grabbing our legal magnifying glasses
It's been right in.
yeah, exactly. Jumping right into a YouTube script that breaks down a massive 2026 Supreme Court case.
Savukku Shankar versus the state.
That's the one. And our mission for you today is to explore this fundamental constitutional clash between the judiciary and the police.
Right.
The central question is honestly pretty wild. Can a judge actually force a police officer to accuse someone of a crime?
I mean, it sounds like something straight out of a legal thriller.
Yeah.
And the facts of this case are just absolutely drenched in dramatic irony.
Oh, totally.
We had the appellant A. Shankar, who was already facing, I think, a staggering 37 cases.
37, yeah.
Right. And he goes to the Madras High Court, essentially seeking a shield from what he claimed was relentless police harassment.
But instead of handing him a shield, the High Court practically gave the police a sword and pointed it right at his chest. The court dismissed his plea and explicitly ordered the police to officially file charge sheets against him within 4 months. So he went in asking for help and walked out with a judicial ticking time bomb on his head.
Yeah.
How does appealing for help backfire that spectacularly? Like, doesn't that violate a basic principle of seeking justice?
It absolutely does. And that triggers the precedent set in a case called P. Radhakrishnan, which established what we call the worse-off doctrine.
Okay, let's unpack this worse-off idea for the listener.
Sure. So the court had to reckon with the simple fact that knocking on the doors of justice shouldn't inadvertently strip you of your existing liberties.
Right. You cannot be placed in a more precarious position just because you asked a higher court for protection.
Exactly. You shouldn't leave the courthouse worse off than when you walked in.
But applying the worse-off doctrine here isn't just about protecting Shankar, though. It's really about protecting the boundaries of the court itself. Because when the High Court ordered those charge sheets to be filed, they essentially stepped out from behind the bench and tried to put on a police uniform.
Which is a huge issue. And that brings us to the strict separation of powers outlined in Section 173 of the Criminal Procedure Code.
And Section 193 of the new BNSS.
Yes. The Supreme Court leaned heavily on a landmark case H.N. Rishbud to reinforce that gathering facts and collecting evidence is exclusively police territory.
So if an investigation is stalling out, courts can issue a writ of mandamus to monitor the progress.
Right.
Which is essentially acting as a judicial cattle prod to get things moving,
Right.
but deciding whether to actually file a charge sheet, that formal legal accusation, that is entirely up to the police.
Correct. The legal term for that is the formation of opinion. The investigating officer alone gets to decide if the evidentiary threshold is met to formally charge a suspect, or if they should just file a closure report.
Okay, so it's essentially like a judge can order the police to go to the kitchen and cook, meaning they have to investigate.
I like that analogy.
Thanks. But they cannot force them to bake a very specific cake if the police don't even have the ingredients or the evidence yet.
That is the exact limitation the High Court ignored. I mean, they were likely aiming for the noble goal of speedy justice by setting a strict 4-month deadline to clear out these cases.
Sure.
But the Supreme Court ruled that this crossed a major line. Setting those rigid timelines stripped the investigating officers of their discretion.
Because it forced the police to act mechanically, just rushing to accuse someone to avoid being held in contempt of court rather than conducting a fair, independent investigation.
Exactly. The Supreme Court actually went so far as to quash 2 newly filed charge sheets that resulted from this order. They explicitly declared that the investigation had been poisoned by the High Court's interference.
Wow. It's a stark reminder of what happens when the mechanisms of justice are rushed.
It really is.
So what does this all mean for you listening right now?
Well, if you are a member of the general public, this case is a massive reminder that due process is your shield against rushed, malicious prosecutions.
The courts must remain a safe haven where you can ask for help, not a trap. Right. And for the legal professionals tuning in, this ruling is a vital reaffirmation of investigative independence. It clearly defines the strict limits of writ jurisdiction.
Speedy justice is a great goal, but it simply cannot crush a fair and unpressured investigation.
It all comes down to that balance of power, but we do want to leave you with something to chew on before we go.
Oh, definitely.
If courts are strictly forbidden from forcing the police to charge a suspect who protects the public when the police deliberately drag their feet or refuse to investigate powerful individuals,
That is the big question.
keep digging into it, keep questioning, and we will catch you on the next deep dive.